When it comes to construction projects in Florida, whether you're building your dream home, a commercial property, or investing in real estate, there's one thing no one wants to face: construction defects. But unfortunately, these issues happen, and understanding how construction defect claims work in Florida can save you time, money, and a lot of headaches. First, let's break it down what a construction defect is. Simply put, a construction defect is any flaw in the design, materials, or workmanship that compromises the safety, performance, or value of a building. This could range from a leaky roof to a foundation that's starting to crack just months after construction is complete. In Florida, these defects are particularly common because of our unique challenges: heavy rains, hurricanes, and even high humidity that can wreak havoc on construction materials if not properly installed or maintained. So how do you know if you have a valid construction defect claim? It's all about identifying the problem and connecting it to an error in the construction process. For instance, if you're dealing with water intrusion, it could be due to improperly installed windows or a faulty roof design. Maybe your foundation is shifting because the contractor didn't properly account for Florida's sandy soil. The key is to work with an experienced construction attorney and, in many cases, a building expert to identify the root cause of the issue. One of the most important aspects of construction defect claims in Florida is the state's statute of limitations. This law essentially sets a deadline for filing a claim. In Florida, you typically have 4 years from the time the defect is discovered, or should have reasonably been discovered, to take action. However, for latent defects or those that aren't immediately obvious, this timeline might start years later. And keep in mind, there's also a statute of repose, which caps claims at 10 years from the completion of construction, regardless of when the defect is discovered. These deadlines can be tricky, so it's crucial to act quickly once you suspect a problem. You're probably wondering, what's involved in a construction defect claim? In Florida, the process often begins with what's known as a Chapter 558 notice. This is a pre-suit law requirement where you notify the responsible parties, like the contractor or developer, about the defect to give them a chance to inspect the property and potentially fix the issues without going to court. This step is important because it can save time and money for everyone involved. If the defect isn't resolved through the Chapter 558 process, the next step is filing a formal lawsuit. This is where having a knowledgeable construction attorney becomes invaluable. They'll help you navigate the complexity of Florida construction law, from proving negligence or breach of contract to dealing with insurance companies and expert witnesses. In some cases, claims can be resolved through mediation or arbitration, which can be less adversarial and more cost-effective than a full-blown trial. It's also worth mentioning the role of insurance in construction defect claims. Both property owners and contractors often have insurance policies that come into play. For example, a contractor's general liability insurance might cover damages resulting from defective work, but navigating these policies can be a challenge. Insurers may deny a claim or try to minimize payouts, which is another reason having a legal representation can make a huge difference. Another critical consideration is the impact of construction defect on property value and safety. A minor defect might seem like a small inconvenience, but if it left unaddressed, it could lead to bigger structural problems that threaten the integrity of the entire building. For example, issues with the foundation can compromise the stability of the property, while water intrusion can lead to mold growth, which poses serious health risks. By addressing defects promptly, property owners can avoid these compounding issues. Now let's talk about preventative measures. While no one can guarantee a defect-free construction project, there are steps you can take to minimize the risks. Hiring reputable contractors with a proven track record and checking the references is one of the best ways to start. Make sure to review contracts carefully and ensure they include warranties for workmanship and materials. Additionally, regular inspections during construction can help catch potential issues early, before they escalate into costly defects. For property owners dealing with homeowners associations, there's another layer to consider. HOAs often have rules and processes for handling construction defect claims on behalf of the community. If you're part of an HOA, it's important to work closely with the board and legal counsel to ensure proper procedures are followed. Another angle to think about is the role of subcontractors. In many construction projects, the main contractors hire subcontractors to handle specific tasks like plumbing or electrical work. If a defect arises from their work, determining liability can get complicated. Florida's construction defect laws allow claims against multiple parties, so it's essential to investigate thoroughly to identify all responsible parties. Finally, consider the emotional toll these issues can take. Construction defect claims can be stressful, especially when dealing with unresponsive contractors or insurance companies. That's why having a skilled attorney on your side is not just about legal expertise, it's about having someone to advocate for you and ease the burden. Florida's construction defect laws are designed to strike a balance between protecting property owners and giving contractors a fair opportunity to address issues. However, the process can feel overwhelming without the right guidance. That's why it's important to consult with professionals who understand the intricacies of this area of law. Ultimately, understanding construction defect claims in Florida is all about knowing your rights and taking proactive steps to protect your investment. Whether you're a homeowner, a business owner, or a real estate developer, don't let construction defects undermine the value of your property. If you suspect an issue, act quickly. Seek expert advice, and remember, you don't have to navigate this process alone. Thanks for joining me to explore this important topic. If you found this helpful, don't forget to like, subscribe, and share this videos with others who might benefit. And if you have questions about construction defect claims in Florida, drop them in the comments below. I'd love to hear from you.